morning, Your Honors. My name is Attorney Paul Brennan, and I represent the defendant, Susan Carcieri. Today, my sister here, Patricia DeJunius of Sibison and DeJunius, represents the co-defendant, George Labadie. We've agreed to divide our time as follows. I will argue for 11 minutes, and my sister will argue for about 4 minutes.
Let me ask you this. Let's assume you win on the question of whether or not this federal credit union is a bank within the meaning of 266-52. Why couldn't your client be prosecuted under the larceny statute, 266-30?
Well, you've taken the words right out of my mouth, Your Honor.
Good.
I think there are two issues in this case. And appeals court held that my client, who was an employee of a federal credit union, who was convicted under Chapter 266, Section 52, which is embezzlement from a bank, and that the court, Worcester Superior Court, did not have jurisdiction over that charge. Since it did not have jurisdiction over that charge, then it had to consider what should it do.
It didn't have jurisdiction over it, or
simply
that
they didn't prove that it, yeah.
No, I think, they didn't have jurisdiction. I think that was the holding. They didn't have jurisdiction. So they then had to decide, well, could we then order remand to the Superior Court for them to enter a sentence on a lesser included charge? And they cited 3 cases where in support of the proposition where it doesn't have jurisdiction in the first place, it can't order a remand.
But is that correct that there wasn't jurisdiction? I mean, listen,
I think so, Your Honor. I mean, first of all, I think the appeals court decision makes in the appeals court decision they are able to point out that the charge of embezzlement from a credit union, federal credit union, is preempted. And
but you've got a statute that says it's embezzlement from banks that are chartered under or governed by the Commissioner of Banks or under the regulation.
Right.
Okay,
Yes.
There's no evidence that this credit union qualifies. That's put in by the prosecution that it's supervised by the Commissioner of Banks or whatever. So why isn't it a failure of proof?
Well, it's a question of jurisdiction because we all agree that it was a federal credit union, and that's not in dispute. If it's a federal credit union, does the Superior Court have jurisdiction in the first place? And based upon established precedent, the state courts are preempted for prosecuting employees and directors, etc., of a federal national banking institution and federal credit unions from prosecuting such people in state court on charges of embezzlement, not larceny, but embezzlement. Therefore, it is a question of jurisdiction. It seems to me if you're just going to emphasize the question of proof, well then, all right, we can prove that it's a federal credit union, then you get to the question of jurisdiction. Either way, you have to confront the issue.
You don't have to prove anything. They didn't prove that it was a bank fitting within the statute.
Well, that's true, but you know that was something that wasn't contested at trial. What the judge stipulated, or the judge instructed the jury as a matter of law that this federal credit union was a bank within the meaning of statute, which wasn't true. It was not a bank within the meaning of statute. And as you can see from the letter from the Commissioner for Banks, which I've included in my brief, there's a dual banking system, and a federal credit union does not come within the definition of a bank in Chapter 157.
I'm just assuming you're right. You're right about that. The question is the consequence. And does the state court, your position is the state court has no jurisdiction to prosecute an employee of a federal credit union for any form of embezzlement from the federal credit union, even under the general larceny statute?
Okay. Well, first of all, I think under this, I'd like to start with the statute, Section 52 itself first. Under that statute, yes, I think the state is preempted from prosecuting my client and Mr. Labadie under that statute because it applies, first of all.
Well, it's not preempted, it just doesn't apply.
It doesn't apply, all right. All right, so then let's focus on Section 30, which is the general larceny statute, which contains 3 theories of larceny. First, straight, simple larceny, embezzlement, and then larceny by false pretenses. Mm-hmm. Now, if you're going to prosecute my client under Section 30, for a larceny by embezzlement, you're still faced with the preemption problem. Whether you prosecute my client under Section 52 or you prosecute my client under Section 30, the problem still remains the same. State courts are preempted from trying my client for embezzlement from a federal credit union.
No,
And that comes from Easton versus Iowa?
Iowa, yes, and also the Supreme Judicial Court in the Commonwealth.
Yeah, it was 140 years ago.
Well, Your Honor,
it
it's
was
still
long before all these federal statutes, which changed a lot of this.
Well,
so-
well, I would just point out, I anticipated that point being raised. Well, I would just point out, first of all, there's been no congressional intent that I can see that that should be changed. Number two, it appears to be something that's assumed by all jurisdictions, because I note, you'll note from the law review article, which I enclosed, which I referred to in my brief. It was a Texas law review article of 1934, which surveyed the law in this area and noted that the courts were holding that embezzlement from national banking institutions were preempted. And then we don't hear anything anymore until today. Which indicates to me that it's been assumed by all the federal courts and all the state courts that embezzlement by an officer of a national banking institution cannot be prosecuted in state court.
Well, you have 18 U.S.C. 3231 enacted in 1948, which talks generally about just because the district courts have original jurisdiction over certain offenses, it doesn't impair the jurisdiction of the courts of the several states under their laws.
I don't think that makes
Well, this
any
is just a larceny. It's just a larceny. Under state law,
No,
it's just a larceny.
we're talking about embezzlement, Your Honor. There's different.
Well, we're talking about a violation of 26630. Call it what you'd like. 26630 covers three forms of larceny.
That's correct,
one of
yes,
which
sir.
is embezzlement.
Well, yes, embezzle and...
Or I should say not embezzlement. It covers converts or secretes with intent to convert.
Well, again, I would stress, the authorities stress that embezzlement is, prosecution for embezzlement is preempted by federal law until some court comes...
That was 1903.
Well, until some court comes along and says to the contrary, it's still good law.
Even though a statute says it does not impair the jurisdiction of state courts over state laws.
Well, no, that's just, you're just talking about the jurisdiction of the district courts. That's been the same ever since the beginning of the Constitution. The question is that, in fact, the predecessor statute to that section was enforced at the time that Easton was decided. Had the same import, and in Easton they held that state courts were preempted from trying offenses, criminal offenses under the committed by offices of national banking institutions. What that statute only says is that there's a dual sovereignty. In other words, further, let's take drug offenses. Drug offenses can be violations of state law and federal law. No, there's no problem under the doctrine of dual sovereignty prosecuting somebody for the same offense in federal court and district court. Same with respect to, like, say, bank robbery. No problem about prosecuting bank robberies in state court, federal court.
Is preemption an affirmative defense that can be waived?
Well, if it's jurisdiction, I don't see it. I don't think, with all due respect, if it's a jurisdictional issue, that the court just simply had no jurisdiction. It's true that the defense counsel didn't raise it, but if in fact, as the appeals court pointed out, the Superior Court did not have jurisdiction, then it's something that could have been that was properly raised on appeal. For the first
And
time.
why is it jurisdictional? Is it just because it's a preemption issue?
Yes, correct, Sean.
Well, but preemption is an affirmative defense that can be waived.
I'm not aware of any such
Okay.
holding, but if it's a jurisdictional issue, I'm not aware of any case that says a defendant can waive a jurisdictional issue and be sentenced to prison by a court that has no jurisdiction to try him in the first place.
But that's not my question. My question is, maybe it's not a jurisdictional issue. Maybe the appeals court was wrong. Maybe it's an affirmative defense that has been waived.
I'm not aware of any case that says that, Your Honor. With all due respect, I think that preemption is a jurisdictional issue. Preemption says that the state court has no business with that law, trying that case. That's what preemption says. And if the state court has no business trying that charge, then that's the end to the matter.
is there a stipulation that this was a federally chartered credit union?
Well, as I think as I briefly pointed out, I'm trying to keep track of my time here, so my sister. The trial judge instructed the jury as a matter of law that a federal credit union was a bank. Well, I don't think it would have made any difference whether he stipulated it or not. The court simply didn't have jurisdiction. This is a question of preemption. And that being so, then the court didn't have jurisdiction to try the case. Now,
You're saying that even if they had not brought the action under 26713, but had proceeded under the general larceny statute, they still wouldn't have had.
that's correct. Under free action, whether you charge under Section 52 or Section 30, that's the end of the matter, insofar as embezzlement is concerned. Now, on the question of law, and I just, in the reign of my brief time, so I can give my sister some time, I would just like to address the question, if the question of the larceny, whether the defendant could be charged now for larceny. Well, it is well established that larceny and embezzlement are separate and distinct offenses. Okay. And that larceny is not a lesser included offense of embezzlement. Now, I guess maybe the appeals court meant to say that, well, there's a separate theory of larceny that could be charged, or could have been charged. Well, maybe they could have charged larceny under the general larceny statute, and that would not raise a preemption problem. That's correct. Commonwealth versus Marcino, that's correct. However, the evidence at trial was, I'll get right to it, the evidence at trial was that she was guilty of embezzlement, not larceny, because she was an office manager and she was entrusted with the possession of the money in the safe. I'd like to then yield the remainder of my time to my sister.
Good morning. Patricia DeJunas for Mr. Labadie. I had planned on addressing the issues specific to Mr. Labadie, that being the sufficiency of the evidence and prejudicial spillover and whether or not a new trial would be required on all charges against Mr. Labadie. Those arguments are laid out, I think, pretty thoroughly in Mr. Labadie's main brief and supplemental brief. So I'd like to address the jurisdictional question that I think Justice Botsford raised, is this a matter of jurisdiction or is it a failure of proof? And I think that in this case, the first place you need to look is at the indictment, whether this charges a state court offense or whether it charges a federal offense. And what this charges is that Ms. Carcieri, Mr. Labadie, being an employee of Wyman Gordon Federal Credit Union, Justice Botsford, I suggest this is not a failure of proof. It is undisputed. This is not a state charter credit union. The only evidence at trial was that this is a federal credit union. The Commonwealth agrees with that, has not challenged that in their brief.
But I don't mean to beat a dead horse, but if this is not a jurisdictional issue, but in fact is an affirmative defense that has been waived, then Justice Botsford's analysis is exactly right.
Well, Your Honor, I don't agree that it's not jurisdictional.
Yeah, I know you don't.
I think it is jurisdictional because the state courts have, the state statute does not apply to federally chartered credit unions, but there is a federal statute that says that an employee of a bank who embezzles from a federally chartered bank or credit union is guilty of embezzlement. I think that this indictment on its face charges Mr. Labadie and Ms. Carcieri with a federal offense. The question then is can somebody who's erroneously charged with a federal offense in state court then be tried or convicted or whether this court can affirm a conviction on a lesser included offense that's a state court offense? I don't think so. I think that what has to be done here is that they would have to issue a new indictment, which can't be done because here we've got such a long passage of time that the statute of limitations has passed. So I think that in this circumstance, where it's undisputed that this is a federal credit union, not a state credit union, it's not just a failure of proof, it's jurisdictional.
But you're saying that if they had charged larceny in the first place under 26630 and not charged the other crime, it would still be preempted. Is that correct? They had charged larceny by embezzlement here.
Under 26630.
Would that be preempted if they had not brought the charge under Section 52?
I believe that it would be for the reasons that are stated in my brother's brief, but that's not what happened here. I think you can't just strike federal credit union and insert state credit union and treat this as just a lesser included offense. We're in a different world here. We're talking federal versus state, and I just don't think that a state court larceny offense can be a lesser included offense of a federal embezzlement statute.
There seems to be some confusion because I think your brief addresses both the counterfeit issues and the this particular indictment, but the further appellate review was limited to the jurisdiction. I mean, the whole question about the bank. Right?
Yes, Your Honor. I'm actually late to this case, but what happened is that when prior counsel filed the blue brief, it was before this court had limited further appellate review.
Okay, so you're not expecting us to reach
So no,
that.
I would not be expecting you to do that. In my supplemental brief, though, I do raise the question of whether or not, if you're going to grant a new trial on or vacate the embezzlement conviction, whether or not that means that Mr. Labadie would be entitled to a new trial on the counterfeiting as well. My reason for suggesting that is that this case, 87% of the evidence was about the embezzlement, about the staged robbery. Very little of this case is about the counterfeiting. The evidence was so weak, I think that there's a substantial risk of a miscarriage of justice that Mr. Labadie may have been convicted on the counterfeiting offenses because of the great amount of evidence with regard to the embezzlement. And I see that I'm up, unless the panel has any more questions. Thank you.
May it please the court, my name is Donna Marie Heron, Assistant District Attorney representing the Commonwealth. What was argued below in the appeals court and what the appeals court found was that the Commonwealth produced insufficient evidence to prove that Wyman Gordon was qualified as a bank under the statute, and that is what the appeals court found, that as a matter of proof, the Commonwealth failed to prove that Wyman Gordon Credit Union qualified as a bank under the statute. The appeals court then went into the issue of whether it could just simply be remanded for resentencing for larceny, or did it have to have a new trial, and that's when it got into the federal.
The word preemption certainly fits in, is discussed by Judge Walhogen.
No, that's when she goes, can this just simply be remanded back for resentencing, and that's when federal preemption was brought up. And the Commonwealth argues the appeals court got it wrong when it said that we were federally preempted from doing that, because if you look at the appeals court solely concentrated on our state statute and the history of our legislation, which is wrong. You have to look at the U.S. Congress intent. Did they intend to exclude, to have exclusive jurisdiction? And when they enacted 18 U.S.C. 3231, they clearly gave the intent that there was going to be concurrent jurisdiction.
Tell me more about that statute. What's the context of that?
It was enacted in 1948, and it said, nothing in this title, which includes, by the way, the federal equivalent of our embezzlement by a bank employee, is in this
Title 18 is the criminal title. Yeah.
Nothing in this title shall be held to take away or impair the jurisdiction of several states under the laws thereof. Therefore, it gives us concurrent jurisdiction. Their intent is quite clear in that statute.
Well, I mean, there's a difference between the general language about it isn't, I mean, just take hypothetically, in this context, it's not intended to supplant general embezzlement versus it's not intended to supplant embezzlement from a federally chartered bank, right? I mean, the language is pretty general in 3231.
Yes, but then there's also been one case, I actually found a case, and it was in the Maryland State Court, which said that it was embezzlement from a federal bank, and they upheld the conviction, and they said it wasn't federally preempted there. And
based on that statute, 18
yes,
USC? And
they also talked about the Easton case, which I would suggest is different. In Easton case, which is predating this statute, they found that I think it was Iowa, made it a crime for the bank to have insufficient funds and accept deposits. And the court there, which I think is different here, said you can't, that's going into the regulation of banks, which they clearly have exclusive jurisdiction, and they've clearly exercised that. And they said by making it a criminal offense for insolvent banks to accept deposits, you're encroaching upon the regulation of banks, and that you cannot do. And that was the holding of that case, that by creating a law saying that it was illegal to do that, you're encroaching on the federal regulation of banks. But again, that predates 1948 when Congress enacted the statute, which clearly gives concurrent jurisdiction.
Clearly gives concurrent jurisdiction over any crimes that might be committed in a federal credit union.
Yes.
Okay.
And that I would
any
suggest
state crimes, not federal crimes.
State crimes, and then yes, and then, okay. So I would suggest the Commonwealth would recommend that this court remand this case back for resentencing under simple larceny, which this court does have jurisdiction over.
Talk to me about Marcino, Commonwealth versus Marcino. I know it's a 1925 case of this court,
which said that we had jurisdiction for larceny from a national bank.
Well, it said we had jurisdiction to prosecute the non-employee. Okay? But the president of the bank, it said, could only be prosecuted federally.
Again, that predates the concurrent jurisdiction,
So you say
1948 statute.
you say your hat is hung firmly on that statute.
It is, Your
And
Honor.
if that statute controls, you say, at this point, we don't need a new trial, that there's been a conviction of the lesser included offense.
Of larceny or larceny by embezzlement, which is a lesser included of this charge. Therefore, we only need to remand for resentencing on those convictions for both the defendants.
Okay.
And is it different if it were ERISA, because ERISA is expressly preemptive? I mean, if you were to charge embezzlement by an ERISA person, by somebody who was in charge of an ERISA trust account, would you say that we could prosecute them for larceny, even though it's federal preemption with regard to ERISA?
I'm not quite sure of the answer, but my argument would be if they exercise exclusive jurisdiction, then yes, I would say we were. But here, you're looking at the elements, and then the employee, her status of an employee and the status of a bank for larceny are no longer elements of that. So therefore, we retain jurisdiction of that. Since we don't have to prove that she is the bank assistant manager, and we don't have to prove that Wyman Credit Union is a bank. Those elements go away under the general larceny by embezzlement.
But you have to prove the elements of embezzlement.
Yes, we would.
Now, what about the co-defendant here, Mr. Labadie?
Yes.
Why do you say there's sufficient evidence there's no evidence he was involved in the theft?
I would say there was sufficient evidence based on the fact that, taking into account the nature of the crime, the fact that while she is being, all the police and all the, well, first, I'm sorry, let me take back. The nature of the crime of the alleged robbery, it was clear that someone helped her set up the alleged fake robbery. At the time that the police are there and are interviewing her, Mr. Labadie is seen across the street, which is evidence that is in direct view of all of this occurring, and he's pacing back and forth on his property and not coming over, not checking it.
So they live right across from the bank?
Yes, there was evidence that you could directly see from their house to where all this is taking place. There's evidence that Ms. Cassier receives a phone call while she's being driven to the police station, and it's from Mr. Labadie, and she becomes very upset after talking to Mr. Labadie. And then all the evidence afterwards.
That evidence of anything? Yes, she's just been arrested. And she's talking to her husband. I guess.
I mean, it was for the jury to decide, but in the Commonwealth.
What is the conceivable relevance of that?
That he's telling her to be quiet and to not talk, because he's realizing that their whole alleged robbery is now going by the wayside. But I would suggest that all the other evidence afterwards, the $4,000 found in the side of the house, all the money secreted under the rugs, the fact that Mr. Labadie goes to Cash Depot, has money falling out of his shirt, and then tries to get money orders just down to the $10,000, which will be reported when the woman who knows him very well says never in her years of doing business with him has he ever come in and asked for money orders. It's usually him cashing personal checks. I think all that, viewed in light most favorable to the Commonwealth, amply supported Mr. Labadie's conviction as a joint venturer in the larceny.
Okay.
No further questions. The Commonwealth rests on its brief and its motion to strike.
Thank you.